The nation's top legal organization is set to approve a controversial resolution that would, get this, you guys, essentially treat all sex as rape unless proven otherwise. And wrongly place the burden of proof on the accused, of course. Fox chief correspondent Jonathan Hunt is live here in our West Coast bureau with the story. Jonathan.
Good evening, Tammy. It seems simple when you first ask the question, did someone consent to sexual activity or not? But consent, which is at the core of so many sexual assault cases, has proven time and again to be very hard to define legally. And that's led to some colleges and legal organizations taking another look at what's called affirmative consent. The American Bar Association, which among other things sets academic standards for law schools, is among those organizations supporting a legal redefinition of consent. Its resolution being debated this week would call on legislatures and courts to, quote, define consent in sexual assault cases as the assent of a person who is competent to give consent to engage in a specific act, and, quote, to reject any requirement that sexual assault victims have a legal burden of verbal or physical resistance. Now, that echoes a California law which summed up the approach as yes means yes, and New York's enough is enough law. The laws, supporters say, are vital to protect victims, particularly in cases where a potential victim might be drunk or unconscious as a result of drugs taken knowingly or not, and therefore unable to resist or to give consent. Critics, among them the National Association of Criminal Defense Lawyers, say affirmative consent laws are dangerous because they take away the presumption of innocence. The NACDL saying any such law, quote, shifts the burden of proof by requiring an accused person to prove affirmative consent to each sexual act rather than requiring the prosecution to prove lack of consent. And adding of the American Bar Association proposal, quote, the resolution assumes guilt in the absence of any evidence regarding consent. Now, it's important to remember, Tammy, these laws are aimed squarely at colleges, and according to the website affirmativeconsent.com, only 40 of 513 colleges they studied have actually introduced affirmative consent policies. Tammy?
Jonathan, thank you very much.
Sure.
Here now to respond is Harmeet Dillon, civil rights attorney and a member of Trump's 2020 advisory board. You're aware of all of the great work that she's doing. You see her often here on Fox News. Harmeet, it's remarkable to hear that report. It is completely Orwellian. We're supposed to be happy that only 40 colleges are doing this. Clearly, this is just the beginning. But this is one of those things where Americans couldn't imagine that this would occur. It also, and I've identified as a feminist most of my adult life. You are a professional woman in a field that has not always been open to women. We both know as American women that we're in charge of our lives. This kind of a law also places a burden in a way on a woman, presuming that she's an infant in certain senses. What is your take in general of the impact of this on women and on everyone's civil rights?
So I agree with you, Tammy. This really infantilizes women, excuse me, and puts the burden of proof on men to prove assent in a setting where there's nobody else present generally. So basically, you're asking men to prove the impossible. Now, it's actually already been the case that many schools have put the burden on men in many ways by not allowing the confrontation of witnesses, excuse me, by not allowing evidentiary burdens to be appropriate the way they are in criminal court, and many other presumptions that make it very Orwellian to be a man.
Well, you know, I think what we've both seen and what most American women have seen is, and we've wanted a shift from what it used to be, where women would be blamed for being raped because of what she was wearing, right? Or that yes. She was asking for it. So We've wanted a shift to have women be taken seriously. We've had these conversations, and yet we've just wanted a fair access to due process and to the legal system. This has moved so far to this presumption that the accuser, and we saw this in the Kavanaugh case, the presumption that the accuser was telling the truth, expecting the accused to prove a negative. And I don't see this being moved at all. I don't see this staying only within these cases. It would be in other cases as well, other fields.
Well, so college students today are being taught that the First Amendment doesn't apply, that the Second Amendment should not exist. And of course, now we're talking about the Sixth Amendment, all the rights that come along with being accused of a crime. And obviously, sexual assault is a crime. So this is part of a trend that's happening in America. So even before this dumb law by the ABA, which is an organization that I actually spoke at their conference earlier today, but I militantly have never belonged to the ABA because they do this type of thing. I actually have a theory here, Tammy. I think this is almost, in a sense, a sinister make-work act for lawyers, because what is certain to come out of this law, if it is passed in the various states, is that there is going to be constitutional litigation, because what they're doing is illegal. Universities and colleges that have these types of burden-shifting premises that violate the rights of men accused are being sued. There's a class action lawsuit going on right now challenging the Title IX burden shifting that occurred throughout the Obama administration. That is still the law in many states. And so I participated in these Title IX proceedings. Men are railroaded, boys are railroaded, careers are destroyed. And are women the better off for that? I don't think so.
Yeah, no, and especially since these are young women and men coming out of the academy and moving then into business and into law, and this is their conditioning, isn't it?
Absolutely.
And it is. It's not what any of us want, to say the least. Harmeet, thank you very much.